I'm Anastasia Feinberg, attorney at Legacy Law Group, Colorado, and today I want to talk to you about 3 very common misconceptions when it comes to estate planning. The first one being that a lot of people think that just because you're married, your spouse automatically gets to make healthcare decisions for you, financial decisions for you, and then also inherit all of your property. That is absolutely not true. In the state of Colorado, there's no automatic presumption that your spouse gets everything from you or that they get to make your decisions for you if you become incapacitated. So if you are married and you have separate property, real estate, bank accounts, whatever it may be, even if you have a valid will that says that you want your spouse to get everything, that transfer of assets is not going to be automatic upon the first death. So the spouse, if you have a will have to take that will through the probate process, and only after that they can inherit your assets. Again, if you don't have a healthcare power of attorney designating your spouse or a general power of attorney designating your spouse, it's not an automatic presumption that they will make your healthcare or financial decisions. It's literally any interested person that gets to make those decisions. So if you're married and you're thinking about doing an estate plan, don't just do a template will, because in a lot of cases that's not going to work for you the way you assume it will. The second most common misconception is that a will avoids probate court. And again, that is absolutely not true. The will actually has to go to probate, so it has to be physically lodged with the probate court, and it has to be an original ink signature will, so a copy is not going to work. And the will starts the probate process, so where basically the will is going to simplify it. The court's not going to have to fill in the laws of intestacy and who gets what. The will dictate it, but wills still have to go to probate. Wills still can be contested and can result in a pretty lengthy and messy process. And then another big misconception is that your will controls all of your assets. And again, that is not true, because beneficiary designations and joint ownership override the will. So in a lot of cases, there's not even probate estate, so the will is not going to control if you have beneficiaries designated on everything that you own, or if you have joint tenants listed on your property. So this works very well for married couples owning accounts or property jointly, unless there's a prenup. But then we still have to talk about what happens upon the second death. And then if it's beneficiary designated to anybody, spouses, kids, make sure that you're not listing minor children or incapacitated persons as beneficiaries, because that again will have to go to probate court, and a conservator will have to be appointed over that beneficiary designated account until your kids reach the age of majority. So I hope you found this helpful, and if you have any more follow-up questions or would like to schedule your free consultation, please give us a call at 303-954-9428.